Meet Leo. He is a software engineer who recently graduated and built Crypto Clairvoyant, a mobile application powered by a highly unique proprietary algorithm designed to analyze markets and predict cryptocurrency price movements. He is now ready to take this project out of the testing environment and launch it as a live commercial financial product for the public. But before he writes another line of code, he faces an immediate threat: competitors scraping his codebase and hijacking the Crypto Clairvoyant brand name. Then there is a sharper, more severe commercial risk. If an app predicts financial markets and gets it wrong, users lose money. And when users lose money, the probability of them suing the creator is exceptionally high. Launching a fintech product requires treating the legal framework with the exact same precision as the software architecture. To secure this product, we have to execute a two-step process. First, stratifying the intellectual property, and second, executing a formal analysis to engineer a corporate shield. Writing a unique algorithm does not grant automatic protection. Without a solid legal structure, the founder is completely exposed to both intellectual theft and personal financial ruin. Technical founders often make a baseline error. They view a software application as a single homogeneous legal asset. We need to apply a concept called IP stratification. This means breaking the software down into distinctly protectable legal components. Looking at this exploded wireframe of the application, we can project the software into three distinct layers: the raw text file of the code, the logo icon representing the brand, and the geometric node network of the algorithm itself. Let's focus purely on that first layer, the raw source code.
Under Australian law, the moment a developer types this raw code and saves it, it is automatically protected by copyright. However, copyright is strictly limited. It only prevents the literal copy-pasting of the text. It offers zero protection for the underlying idea or logic of the application. That brings us to the second layer, the brand identity, specifically the name Crypto Clairvoyant. To protect this name from competitors trading on his goodwill, Leo must actively register a trademark with IP Australia. A registered trademark legally blocks rival applications from using confusingly similar names to siphon away his user base. Copyright and trademarks easily secure these surface-level assets, but they leave the core predictive engine of the app completely unprotected. That leaves us with the third, most valuable and most vulnerable layer, the predictive mathematical algorithm itself.
Pure mathematical algorithms are notoriously difficult and often impossible to patent under Australian law. When patents are unavailable, a developer must rely on the required legal alternative, the trade secret. This flowchart demonstrates the mechanics of a trade secret. It is not a government registration. It is an active, internal operational protocol designed to ensure the algorithm never leaks. The primary legal tool used to enforce this fault is the Non-Disclosure Agreement, or NDA. Leo must execute an NDA with every single collaborator, contractor, or investor who is granted access to view the codebase. Because the algorithm cannot be patented, its legal survival relies entirely on the founder's operational discipline and strict access controls. With the software secured from competitors, the danger shifts from rivals stealing the app to users legally attacking the founder. If the app predicts a cryptocurrency movement incorrectly, a user could lose thousands of dollars and sue Leo directly for those damages. To engineer a defense against this liability, we must utilize a rigorous legal methodology known as the IRAC framework: issue, rule, application, conclusion. We can map this legal analysis clearly onto a four-quadrant grid. Starting in the issue quadrant, we define the central problem. What is Leo's personal commercial liability if users lose money, and how can he shield his personal assets? Notice this red liability vector. Right now, it bypasses the application entirely and points directly at Leo. If Leo launches as a sole trader without structural intervention, his personal savings and assets act as the default collateral for the app's predictive failures. Moving to the rule quadrant, we identify the specific legal doctrines that solve this issue. The first rule is the Separate Legal Entity Doctrine under the Corporations Act 2001. This establishes that a registered company is a completely distinct legal person from its human founder. The second rule draws on Australian consumer law principles regarding financial products, validating the legal weight of commercial disclaimers. We now cross into the application quadrant to map these theoretical rules onto Leo's specific crypto scenario. Applying the first rule,
Leo must incorporate a proprietary limited company, or PTY Ltd, to create a corporate veil. This ensures the lawsuit hits the company, not his personal bank account. Applying the second rule, the PTY LT must mandate strict terms of service before a user can access the app, explicitly disclaiming the algorithm as data analysis, not financial advice. Finally, we reach the conclusion quadrant to finalize the operational directive. Leo must not launch personally. He must incorporate Crypto Clairvoyant PTY LT and legally assign all of the app's intellectual property into this new entity's name. The separate legal entity doctrine functions as a critical, legally recognized blast shield, isolating the founder's personal life from the company's liabilities. We have transitioned Leo's project from a highly vulnerable raw codebase into a structured commercial framework. This master diagram visualizes our merged methodologies. The proprietary limited company's outer barrier envelops the copyrighted code, trademarked brand, and NDA-gated algorithm. This unified stack operates defensively. The PT Ltd holds the trademark and copyright, enforces trade secret NDAs, and absorbs user liability. Navigating the fintech sector requires executing this exact sequence: stratify the intellectual property, and then engineer the corporate liability shield. Skipping these steps undermines the value of the software engineering itself. In the fintech space, an unprotected algorithm is merely a donation to competitors and a magnet for litigation. True innovation requires precision engineering of both the code and the law.